What should you do if you're selling a haunted house? I'm Adam Gearey, Professor of Law at Birkbeck University of London, and I'm here to shed some light on the shadow side of property law. Of course, if you're selling your house or flat, the right thing to do is disclose issues like a broken boiler or faulty wiring. But what about paranormal activity? If you've heard strange footsteps at night and nobody was there, or felt a chilling presence at the top of the stairs, or have a room which you simply refuse to sleep in, do you need to tell the buyer about these things? The law gets tricky when we move from physical defects to paranormal issues. Let's look at some legal cases, some precedents, which may help us to resolve the problems that we are thinking about. In one famous American case called Stibovsky and Ackley, a court ruled that a buyer could cancel the purchase of a haunted house because the seller hadn't disclosed the haunting. The court argued that the buyer couldn't be expected to know about local rumours and ghost stories, nor could the buyer be expected to discover paranormal activity during a house inspection. The courts even stated that ghosts, whether parapsychic or psychogenic, could fall under the law's jurisdiction. Over here in the UK, things are a little bit different. In the case of Sykes and Taylor Rose, the sellers didn't tell the buyers that a brutal murder had taken place in the house. This was because when they had bought the house themselves, they hadn't known, only discovering the gruesome facts at some point later on. Furthermore, the seller's solicitor had told them they didn't need to disclose the history of the property. In this instance, the court ruled that it was up to the seller to be subjectively honest. In other words, if the seller genuinely didn't believe this information was relevant to the buyer, they didn't have to reveal it. This ruling makes hauntings extra complex. If you honestly believe your house is haunted, do you have to tell the buyer? The answer might be not really, as long as you really believe, it's not important. Another case is that of Low Cottage in 1999, which the press dramatically referred to as a judicial exorcism. A couple bought the cottage and later refused to pay the remainder of the purchase price, justifying this in court by saying they were haunted by visions of a pig-faced boy and other apparitions. The judge rejected their claims of paranormal activity and expressed profound doubts about the nature of the haunting. But the paranormal has been accepted in British courts before. There's a case called McGee, in which a family claimed their house was haunted by poltergeists, and they even managed to secure a rent reduction because of this paranormal activity. This suggests that while rare, the law can sometimes acknowledge ghostly activity, especially when it impacts upon a family's ability to live in their home. So, should you tell the buyer about your haunted house? Legally, it may not be required, especially in the UK, where the courts tend to focus on the seller's honest belief. If you don't believe the haunting is important, you may not need to disclose it. But remember, honesty is always the key. And who knows, the buyer might even pay more for the dubious thrill of sharing their new home with ghosts.